May it please the court, my name is Robin McKinney of the National Bar. It's a pleasure to be here today. Once upon a time, Chandler Gant.
Hang on just a second.
Oh, I'd like to reserve 2
We'll
minutes.
just let our students
Okay.
exit. Glad
Thank
you
you
were
all.
here, folks. Take care.
The pressure's off.
Yeah.
Whenever I see students at a sentencing hearing, I ask for a continuance.
I thought you'd be anxious to show off your advocacy skills, Mr. McKinney.
I don't know, Judge. I'm just a poor old man trying to get by in this world.
Yeah, that makes 2 of us.
Once upon a time, Chandler Gant went to a friend of his house in Robertson County, Tennessee, near Greenbrier. And Chandler had too much to drink, and his friend drove him down to the local Sonic in Greenbrier in a 4x4, and somebody else was there to get something to eat, as most people sometimes do after they've been drinking. And the music was loud in the 4x4, and one of the workers from Sonic came to tell him to play it down. And a little discussion ensued between Chandler and the employee at Sonic. And the employee at Sonic said, "Come get you some." And in some areas of Tennessee, "come get you some" is an invitation to mutual combat. And unfortunately, Chandler assaulted him. He was charged with aggravated assault. He ultimately, through negotiations, the charges were overcharged, and he entered a plea to simple assault with a sentencing hearing. And he accepted responsibility. Then, at the Senate, before the sentencing hearing, he decided to take an anger management class, no court order. He took an alcohol and drug assessment, no court order. He met with the pre-sentence report person, with his lawyer. He got the lowest risk assessment you could get by the Tennessee Department of Corrections, and went to the sentencing hearing. He had letters of character letters. He introduced his certificates. His family was there. He made an allocution, and he said the most 2 important words that you can say at a sentencing hearing. "I'm sorry." I'm sorry to the mother of the person that he assaulted, and to that. However, court, the court did not think that was enough. Judge Goodman, who is a wonderful judge, got mad at that case because he felt that he went over beyond the pale. In fact, the judge finding that Mr. Gant gave no justification for his actions, and that was the reason for incarceration. And that's found in the technical record, page 29, lines 10 through 17. He said he was sorry in his allocution. Is that not enough? The court sentenced him to 30 days to serve on a simple assault on weekends, and he ordered him to be taken into custody immediately. Not a stay, not to make preparations, to deny us an appeal bond. And then finally, we filed a motion both in the trial court and here for an appeal bond, and the Judge Wiedermeyer wrote the opinion about that. And the court gave him a nominal appeal bond where he has not been arrested or done anything since then. The issue that we have today is whether the court apply the sentencing factors under 40-35-103 about confinement. Justice Cardozo had one of the greatest lines ever when I was in law school. "There is no such thing as justice. There's only the law." And the Tennessee legislature set forth that sentences involving confinement should be based upon the following considerations. Confinement is necessary to protect society by restraining a person who has a long criminal history. Well, Chandler, like a lot of people, had a DUI in Sumner County, Tennessee. And he survived probation in Sumner County, Tennessee, one of the toughest venues that there are for probation. And he has just one blip on his record. Confinement is necessary to afford appreciating the seriousness of the offense. There was no proof by the district attorney that simple assault, aggravated assault was rampant in Robertson County or that judicial district, which includes Montgomery County.
We're not talking about deterrence there, are we? I mean, we're just talking about depreciating the seriousness of this offense.
Of this offense, yes, sir.
And I know it was pled down to a misdemeanor, but this seems like a pretty serious assault on an autistic 17-year-old.
Yes, sir. That was some of the factors that the DA took into effect is the voluntary intoxication of Mr. Gant, whether that was in fact a serious bodily injury. I cited the case out of Memphis where somebody got through and through gunshot wound, and the Court of Criminal Appeals did not declare that a serious bodily injury. So there was some tough negotiations in this case. So, and you're right, Judge. It was a serious offense, and he's the subject of a multi-million-dollar lawsuit about that. So they're trying to seek justice in the case where, and that was one thing that Judge Goodman talked about. He says, I wish I could put them back the way they were, but he can't. And the only way that we can put them back the way they were is award money damages in that civil lawsuit. And I agree with the court on that. But in this, a simple assault happens every day. And he owned up to it. He did matters that the court could look at, that I took an alcohol assessment. I took an anger management class. I did these things without being told by the court. These were voluntary things that he did to show to the court that he was serious about what his actions. And I understand completely. It was a whipping, a bad one. It was beyond the pale. But the way I read this appreciates the seriousness. There must be some indication that vehicular homicide or whatever other crime is rampant in the community, and there was no proof put on by the district attorney of that, to my recollection of the record. But I understand the court's comments about that. The last factor is measures less restrictive than confinement have been frequently used. He's only had one prior blip in this case. And the court could have considered other things like public service work, volunteering, things least restrictive than confinement. Confinement is something that's serious. What does confinement serve other than retribution? And granted, some people need that. Some people need a timeout. Hardened criminals who do bad things, and the legislature has recognized that. They've recognized that certain things with truth in sentencing, things like this, they need not a little timeout, but they need a big timeout. But in this case, the district attorney's office recognized the weakness of their case. They agreed to reduce the case with the family's consent under the Victims' Rights Act. But they wanted a day to be heard to let Mr. Gant know what this has caused this family. And they did, because I was there too, and I listened to the pain, and I listened to what happened to him. And I was sorry too, as the way the judge was. But the only thing we have is these issues about confinement. It's like one day I was in court talking about a case, and they was talking about confinement. I want so many days. And I said, the DA says, what factors under this apply? He says, none of the factors apply. I just wanted to have those many days. So we have this willy-nilly aspect of how district, and I never was a district, how do you determine what days equal what punishment? There's no formula that we say that we broke your finger, you get 10 days in jail, or we do that. We don't have a mathematical thing. I wish we do. I'd probably be out of a job. I'd probably be at McDonald's flipping quarter pounders or something. But we have a schedule. We have a thing that the court looks into. It's kind of like, I was at a conference in South Carolina. There was a judge that was talking about vehicular homicides and how we do it. And it's kind of weird about how trial judges do his sentencing. You have like a big blender or food processor, and you throw in his prior record. You throw this, you throw that in, and there's no really guidance. And so you put all this stuff in the food processor, like his character letters, his job. Judge Goodman even said he's not lazy, he's a hard worker. And you throw all these things into the food processor, and you blend it all up. And then you pour it out and say, well, this is how much time I should give him. I wouldn't want to be a judge, because I don't know what I'd do. Because judges have the hardest thing in the world to do. How do you balance these competing things? You've got a young man who, other than 2 blips, is a good guy. I've known him for a while.
Well, let me just stop here for a second. This is a situation where, and you say a blip, but he did have a prior crime involving alcohol.
Yes, sir.
Okay? And, looking at it from the standpoint of a trial judge, he says, okay, he's already been down this road once before. He's been on probation once before. He's been through some kind of a either alcohol safety school or some form of, at least some form of a counseling light, not a full rehabilitation program, but it's counseling. And then you have a situation like this, which is totally senseless, alcohol involved, pretty serious injury that comes out of it. And the judge decides that based on the severity of this injury, the situation involving an autistic teenager, all those circumstances, he comes up with a sentence that doesn't require full incarceration, but 30 days periodic. Now, there is no presumption under misdemeanors for alternative sentencing, but he went ahead and gave him an alternative sentence. And from what I'm hearing from you is that he abused his discretion because he didn't give him full probation.
Judge,
So-
I think he could have done something else.
But again, it's his discretion.
It is his
And-
discretion.
And he does have factors to consider that justify not giving him full probation. But also took into consideration things that said he doesn't deserve to be incarcerated full-time, something in the middle. Again, it's within the range, it's within, I would say, the discretion of the court on a misdemeanor especially to make that kind of call.
And Judge, I agree with you, probably 98%, if the court would have articulated his findings. And the court only made one statement about why he gave, because the court's findings, he gave no justification for his actions. He did not go through some of the courts, through some of the judges, a litany of the factors they considered. He did not, in his decision, he did not really go through any of the factors of 40 to 35, 103. He didn't set forth all this. So I really don't know what he was thinking. Now, if he had articulated that I might not be here. And I might say the judge was right, but, and again, I was there. I just think he got mad. And I got mad at Chandler too, a little bit. But if we look at the law, the courts have to articulate. They just can't say, I'm going to give him 10 years to serve because I don't like people with red hair. They got to articulate something on the record. That's what y'all have created. Is this colloquy about why I do what I do, so that the reviewing courts can then have the insight on what was in his mind, what was in his opinion, what he was thinking. And to me, when he ordered him to go straight into custody right from the sentencing hearing, that was an abuse as well. That you could have had a delay to.
And again, that delay, that's up to the judge. And I remember when I was a trial judge, I'd tell folks all the time, hey, you're going to ask for probation, but you better bring your toothbrush, because if I don't grant it, we're not going to play this. Well, I got to get my affairs in order. You go ahead and get that done, and just whatever happens, happens. And you said a bond was set in this case?
Well, the bond was set about 2 or 3 weeks afterwards. The court really denied the stay, and then denied an appeal bond. I filed a motion both with the trial court and the Court of Criminal Appeal, this court, and then about 2 weeks later, after he had served a couple more weekends, the court did grant a nominal bond on that case.
Okay.
And I know that the trial judges are in a tough job, that's the toughest job y'all have. It's easy to make objections about admissibility, but it's tough about sentencing. I mean, y'all are y'all aren't doing that anymore, but
That's why we have these jobs now.
well,
Too hard.
it's easier. Like, I work for a trial judge, and he always, this is what he told about the Court of Criminal Appeals. He says, trial judges are like the infantry. They go in and fight the battle, and the Court of Criminal Appeals comes in and stabs the wounded. So I always like that, but I probably shouldn't have said that today. I'm probably going to lose because I said that. But in this case, Chandler Gant was deserving of full probation. He took the steps necessary, the proof of what he did. I'm a big believer in remedial measures, because I'm the one that told him to do that alcohol assessment. I'm the one that told him to do the anger management class. Because when you're going on a date with a judge, you want to have to brush your teeth. You want to be at your best presentation possible. And he did everything that I asked him to do. And he accepted responsibility in this case. Granted, he took a plea. He avoided a felony. So it was a good result. I just didn't get the perfect result. I was wanting maybe a little bit less time. He served the day that he got arrested, and then 6 more days, so he's got 7 days jail credit on this. I'd ask the court to remand it and order him to maybe serve another weekend or 10 days, and to, sometimes when I go in to visit people, when I hear the clang of the sealed door, it sends me a message that, hey, I better do right. And maybe he needs a little bit more time. But I think 30 days is excessive on this. He has started a career, and he's doing well. There's been some post-judgment facts I can't really talk about, but, he's doing well. And I would just ask the court to consider either remanding it back, let it be a time served, let him start probation, or fashion out 2 more weekends, and that would give him a total of 10 days. So the court here has a lot of options they can do. You're not tied by the hands. But I would just, I've talked too long, and I appreciate the court's consideration for this afternoon. I didn't know I was going to be on YouTube today, so I'm a little scared and nervous. So I appreciate y'all's time and consideration. And Judge Campbell, I understand that. And like I said, I wish I had the magic formula. But sometimes in this life, we have to take a chance that somebody is going to hear what their court articulated and live up to what he heard and live a good life. And I think that Chandler heard those words from Judge Goodman. At least I pray he did. Thank y'all.
Sir. Thank you, Mr. McKinney. General, good to see you again.
It's good to see you, Your Honor. Good afternoon. May it please the court, Ben Ball once again on behalf of the state. Here, the trial court acted well within its discretion in ordering the defendant to serve 30 days of his 1129 sentence in confinement over the course of 14 weekends. Opposing counsel began his argument with once upon a time. I would propose to this court this is not a fairy tale, and I'm sorry are not magic words. There's another story to tell here, and it begins with once upon a time in Greenbrier, Tennessee in May 2021. There was a 17-year-old autistic boy who was working as a cook at the Greenbrier Sonic making $10 an hour. As I mentioned, he was autistic, he had once been nonverbal, and he had worked hard to become a straight A student and enroll in college, which he was attending at the time of the sentencing hearing. As a cook at Sonic, he had virtually no public-facing interactions. He was a cook. On the day this happened, he became aware of loud music as he was cooking, and other employees told him that they had asked a customer outside to turn it down. This customer was the defendant, and he would not turn the music down. And he interacted with several Sonic employees, but he did not interact with the victim. Hearing the commotion, the victim went to the window to look outside, and there he sees the defendant. And he misinterprets the defendant's actions outside as being playful. The defendant asks someone from Sonic to come outside. As the victim pushes open the door, before his hands can even leave the door, he has been punched in the face by the defendant and seriously injured. And as he moves away from the defendant taunts the 17-year-old boy that he has just punched in the face, who he has never seen before. It was not unreasonable for the trial court to ask the defendant to serve 30 days of his 1129 sentence in confinement on weekends. And I want to be clear here, we're talking about misdemeanor sentencing. And misdemeanor sentencing we look at differently. We don't have the same stringent requirements for findings, and we ask ourselves, is this sentence arbitrary? This sentence is not arbitrary given these facts. These facts are egregious. They go well beyond a normal assault. Additionally, while the defendant stood up and said, "I'm sorry," in his explanation, his excuse, he says, "I'm sorry, but I was taunted by an employee at Sonic." But it's clear from the victim's testimony, and there's no evidence in the record here of this "come get you some" comment. And it certainly didn't come from the victim. So he did not give an explanation for this behavior. And "I'm sorry," while a good sentiment, doesn't make this sentence arbitrary. The trial court acted well within its considerable discretion here, and frankly, I believe the defendant was probably fortunate to receive the sentence that he did. If there are no further questions, I would ask this court to affirm the judgment of the trial court.
Thank you, General.
Sir.
Thank you, Your Honors.
May it please the court, I've taken enough of your time. I may be rebuttal and request to be excused.
All right. Well briefed, well argued, as usual,
Yeah.
and we'll take it under advisement.
Thank you, counsel.